Hi, good afternoon. This is a Supreme Court judgment under the Consumer Protection Act. Citation is Hong Kong and Shanghai Banking Corporation versus Avas and others. The facts are very briefly a trust as a voluntary consumer association filed a consumer complaint before NCDRC on behalf of credit card holders. Issue was whether charging of interest of more than 30% by the banks on the credit card holders who delayed and defaulted in payment was an unfair trade practice or not. NCDRC held that it is an unfair trade practice. So the order of the NCDRC was challenged by the banks before the Supreme Court. Several contentions were raised by the banks. So let us not see those contentions. The respondent also filed cross appeals. Now, the first issue was whether the respondent, that is the trust, whether it has a locus standi or not before the NCDRC to file the consumer complaint on behalf of the various respondents. Supreme Court says that if somebody wants to file a consumer complaint on behalf of several consumers, then the first thing is they have to file an application seeking permission of the NCDRC to file that complaint on behalf of several consumers. This was not done by the trust. They only filed that application after the arguments were over and the judgment was reserved. That is too belatedly. So, Supreme Court says first, it was not filed. Second, trust is not a person under the Consumer Protection Act who is entitled to file a consumer complaint. Third, Supreme Court said this consumer complaint, Supreme Court, after perusing the complaint, says it looks like an public interest litigation, but filed as a consumer complaint. Then, fourth, the Supreme Court said the interest, the consumer, the interest charged was only 90,000 rupees. So, 90,000, I think the present limit is about 2 crores or 5 crores. I'm not very sure about that. But the complaint can be filed only if the amount of dispute is more than 5 crores or 2 crores. But the amount of interest in that complaint was only 90,000. So in that on that ground also it says the pecuniary jurisdiction of NCDRC was not there. Then Supreme Court says the fixing of rate of interest is a policy decision of RBI. Court, the NCDRC, uh, cannot interfere with the policy decision of the RBI. Um, the view of the NCDRC that any complaint to curb unfair trade practice that can be entertained, that is also correct. That is what Supreme Court says. Then, with regard to the decision of NCDRC, that any interest above 30% is usurious, is contrary to the legislative intent, and is an encroachment upon the domain of RBI. That is also Supreme Court said. Then Supreme Court says it is no more res integra that any direction or guideline issued by a statutory authority, it is an extension of the statute itself. So rules made under the statute must be treated for all purposes of construction or obligation exactly as they were in the act. So the RBI circulars, the guidelines, etc., it must be read as a extension of statute. That is what Supreme Court says. So Supreme Court said NCDRC has no jurisdiction to entertain that complaint filed by the consumer. Then Supreme Court, these are all the another aspect. Supreme Court examined the contract. Supreme Court held this is very very important because in all contract matters these things can be applied. That is why I want to stress on this. Supreme Court says the terms of the contract executed between the parties are not open to judicial scrutiny. unless the same is arbitrary, discriminatory, malified, or actuated by bias. So the courts cannot strike down the terms of a contract because it feels that some other term would have been fair, wiser, or logical. What the terms of why this comes into question was before issue of credit card or after giving a loan, the terms of contract, there is a contract entered between the banks and the credit card holders. So Supreme Court says once the terms of credit card operations are known to the customer, which is disclosed by the banks before issue of credit cards, then NCDRC could not have scrutinized the terms and conditions, including the rate of interest. Supreme Court said if respondent had any grievance on interest, because the case itself was we were charging more than 30% interest on delayed payment or defaulted payment. So if you had any grievance, you should have approached RBI for that purpose. That is what Supreme Court says. Supreme Court again said that the to re-agitate the terms and conditions of the credit card facilities or to rewrite the terms, including rate of interest, is exorbitant. Supreme very very specifically says, however reasonable. So Supreme Court also feels that charging more than 30% interest is not reasonable. So it says, however reasonable, is an attempt by NCDSC to write a new contract, which is impermissible. It is a settled canon of law. A contract being an agreement between two or more parties, it is to be interpreted giving the actual meaning to the words contained in the contract. Supreme Court said it is not permissible for the court to make a new contract, however reasonable, if the parties have not made it themselves. So, on the ground that the contract is not reasonable, court cannot create another new contract, new term of the contract. That is the point which Supreme Court said. Then Supreme Court further goes ahead and says, if a person signs a document which contains a contractual term, normally parties are bound by such contract. So this is very very important. When you sign a contract, then you are bound by that contract. It is for the parties to establish the exception. That is, if you are suppose compelled to sign that contract, you have to prove that. When a party to the contract disputes the binding nature of a signed document, it is for him to prove the circumstance under which the contract was signed. So on that ground also it says NCDRC had no jurisdiction. Then on unfair trade practice, Supreme Court noted the ingredients of unfair trade practice in the case of Colgate Palmolive. That is a case in which what are the ingredients of unfair trade practice have been mentioned. Let us not get into that. Whether an act is this is very important. Whether an act is an unfair trade practice or not, key is to examine the modus operandi. That is, whether there is any false statement, misrepresentation, or deception is there. That must be seen. That is the uh, crux of the unfair trade practice. Supreme Court says banks did not commit any such act. Customers were made aware of the most important terms and conditions when you are taking the loan or not paying the amount on time. So, NCDRC is not empowered to set aside the unfair contract, which symbolize a single will or unilateral dominant of the banks, or incorporate terms which are unfair or unconscionable. The credit card holders were made aware of the terms and conditions, hence that is also not correct. This is what Supreme Court said. Supreme Court allowed the appeal of the banks. My view is, I am not sure whether anybody has gone through the entire terms and conditions of the contract entered with the banks or the insurance companies. Normally, even medical insurance companies, they send the first page of the document. The balance pages nowadays it is not coming through post. They are sending it by mail, and in that mail they are sending only the first page of the document. Carefully they are sending this because they are. I handled one case in which when my client claimed something, they said no, this is not there because you see the entire contract. This is not covered under the contract. It was not covered under the contract. When I asked my client where is the full contract, he said no, I received only the first page of the contract. I did not receive the full contract. Now only they are sending it to me. So that is one point which is to be noted. Secondly, charging of more than 30% interest by banks, I am unable to digest because I don't delay in my payment or commit default in my payments. So I don't know whether they are charging more than 30%. In assume if that is the case actually, they are charging more than 30% interest. That is atrocious and undigestible for me as far as I am concerned. In Tamil Nadu, we call whoever charges more than 30%, we call them as Kanduvetti Kandasamis. That is, the small traders, the platform traders, they will be there. They will not get any loan from the bank. Bank will give only loan to the fellows who will run away from the country. So they will give 100 crores, 200 crores, 2000 crores. But the small traders who are very honest, they won't give. Maximum number of them will be honest, according to me, because what they do is they take loan from lenders. The lenders, if they want to give 100 rupees, they will give only 70 rupees. 30% interest will be cut, and that 100 rupees that day evening they should give after making the sale. So that is why they are called Kanduvetti Kandasamis. So similarly, the banks charging more than 30% interest, then I think we will be correct in calling them as Kanduvetti Kandasamis. Finally, my view is even Supreme Court appreciates charging more than 30% interest. That is seems to be it is unreasonable. That is what it says. However reasonable the case may be, Supreme Court says NCDSC has no jurisdiction. Having said that, Supreme Court in many a times I have seen in many judgments they have directed to make a suitable law to curb some unfair trade practices or otherwise also they recommend they suggest to the ministry. Similarly, they could have suggested it to the Reserve Bank of India, saying that this much interest you should not permit them to charge. You should fix the maximum rate of interest that should be charged by the banks. That is my view, with greatest respect to the Supreme Court. Anyhow, the issue is whether NCDFC can interfere with the charging of interest by the banks. Supreme Court says they cannot interfere, even though they charge more than 30% interest, because Banking Regulation Act says that a court or tribunal cannot interfere with the charging of interest rates in the activities of the bank. That is only within the domain of the Reserve Bank of India. Thank you very much. Have a great day.